Welcome to Southwest Florida Real Estate Update, hosted by area realtor Jim York and York Real Estate Group of Downing Fry Realty. Our show will bring you the most up-to-date information about the local real estate market, featuring leading experts in the real estate field.
Good afternoon and welcome to the Southwest Florida Real Estate Update. I'm Michael York with the York Real Estate Group, and I'm joined today by our host Jim York and his guest Don Ross of Ross Title and Escrow.
Thank you, Michael, for the introduction. Well, we're here today with Don Ross, local attorney. He's on our show monthly.
How are you doing, Jim?
Today's our legal update. So, Don, before we get into our subject today, which is going to be ethics, why don't you just tell us a little bit about yourself and your company?
Well, I'm an attorney. I went to law school and graduated in '81, got my master's in tax in '82. I am a shareholder in Ross, Lanier & Dyfick, a law firm. I own my own title company, Ross Title and Escrow. I'm a shareholder at Downing Fry. I've been the attorney there for 25 or so years. My office is on the corner of 6th Avenue North and 41, approximately 8 people, fairly busy. And for purposes of all this, I have actually taken and passed the real estate exam twice and the broker's exam once. Let them all lapse, so I'm not out there selling.
Right.
So this will be interesting.
So you're an attorney. You also have a tax degree, right?
Yes, I have a master's in tax.
And then you also have a title company.
Yes.
So, for our viewers.
Some
okay.
people don't like lawyers, so I have a title company.
Exactly. I don't know.
True.
So today we're going to talk about ethics because, you know, we've covered a lot of topics during the past couple of years here every month. But ethics is, I think, is an important subject because in our business, you know, people think maybe us as a lower class person as a real estate agent. So,
especially me.
right,
Yeah.
but we are supposed to follow a code of ethics. So we have 17 articles that we're supposed to follow. So maybe we could start with article number one here.
Well, actually both Articles 1 and 2 we're experiencing a spike in both articles in Collier County right now, I've been told, which is against the past trends. Usually when the market is going well, there are fewer ethical complaints, yet for some reason we're having a spike when things are actually going fairly well. And Article 1 is honesty. And this is the National Association of Realtors. It's
Right.
This particular volume. They sell it at the Naples Board of Realtors. You can get it online. It has all sorts of helpful information in it, but it includes both arbitration, which is fighting for commissions, and then your basic ethics. But the first ethical rule is that the realtor has to deal with everyone with honesty. The penalties, and again I'm prefacing a lot of this,
Right.
The hearing panel at the Naples Board of Realtors can obviously dismiss a charge. They can issue a letter of warning that goes into a confidential file. They can issue a letter of reprimand, which is a little sterner. They can fine the realtor up to $15,000, and I know of a case where somebody got fined for $1,000 the other day. And then on top of that, they can require attendance at classes if they determine that somebody is just new and they don't know that much about their trade. They're not experienced. They haven't been doing this long enough, so they're making mistakes. So the board, in my experience, actually makes an effort to distinguish between realtors who are just nasty, rotten, lying people and people who just need some more class time.
Right.
And honesty is the crux of everything. If we're honest with everyone we deal with, assuming we are courteous as well, that'd be nice, there shouldn't be any problems. So Article 1 deals with honesty, and you must deal honestly with the public and your cooperating brokers as well.
And about disclosing things with properties, that's part of being honest too, right?
You cannot mislead anyone. You have a duty to disclose any latent material defects. That's case law as well as an ethical rule. and even things that come up after you have an accepted contract, you need to disclose. If you're transactional in most cases.
Right.
And as a transactional agent, you, Jim, you can't say how low the seller will go in accepting any offer or how high the buyer is willing to go, and you can't say the motivation of the parties.
Right.
You know, somebody's desperate for money and they really, really, really need to sell this thing, unless you have their permission. But everything other than that, you're supposed to disclose. So I always, as the attorney for Downing Fry, ethics really, I've been exposed to a lot of ethical issues because of that position more than my real estate closing business. I've seen every ethics complaint filed for the last 25 years with anybody at the company. It's a large company, and some of them are frivolous. You get people with hurt feelings, and occasionally you get somebody who is new, and they just don't know, and they didn't ask. They don't want to bother. So I would say to the public, you want somebody experienced, it just goes smoother anyways for all the reasons we've discussed in prior shows, and you don't get dragged into one of these ethical issues.
Yeah, I took that course a couple days ago. The ethics course, you have to take it every so many years.
3 hours, is it?
Yes, it is. And what was interesting is that even you can't even put, like, you have a motivated buyer in your description.
Well, you look at the notice on the transactional form, you cannot disclose motivation.
That's right. So,
unless they give you permission.
Right.
That's why the short sale addendum that was prevalent for a while, we had to put in there. One of the reasons for that was to show motivation. You had the permission of the seller to say, yep, it's a short sale. I owe more than the property is worth.
Yeah, and the other thing they mentioned is that in the description when the property is, you can't disclose that it would say it's the biggest lot in the community or the best lake view in the community. That's another violation of the ethics.
Yeah, I mean, a lot of these words can be interpreted in many different ways. I've got one ethical complaint where one realtor referred to another realtor as clueless. Now, when you dig into the facts of the matter, there was a bankruptcy involved, and there were a lot of technical issues, and at least according to the realtor, what he was referring to was that the other realtor didn't know about the bankruptcy and the technical issues. But just even using politically incorrect language could be construed as something that's disparaging.
Yeah, well, let's go on to Article number 3 and Article number 4. If you have that in front of you there.
Okay, well, Article 3, you're supposed to cooperate with other brokers, except when it's not in your client's best interest. And actually, I remember you getting some hostile phone calls from another realtor because your seller refused to make certain repairs.
That's right.
And what the other realtor didn't realize was the contract allows the seller to refuse to make certain repairs under the NABOR contract.
Exactly.
There's no obligation on the seller, and I think some pointed comments were made to you that wasn't fair or nice or something along those lines. But by cooperating with other brokers, that leads me into if you have a pending sale, and let's say it's subject to financing and it's subject to inspections and there's a due diligence period, you still are supposed to put it in multiple listing service as a contract that's pending. You can't just have it active.
That's right. Because
what happens is, and I've actually had this happen, and I've been to the ethics hearing where this agent was sanctioned for this. Assume you get a client who's very anxious to buy in, say, Tiburon or some golfing community, and they're willing to spend $2 million. And you look in MLS and you find, oh, this is perfect. And you bring your client to that property, and the client falls in love with it, absolutely just loves it. And then the listing agent tells you, well, there's a contract. We're waiting for the due diligence period to run out. We're waiting for the financing contingency. And there you have your buyer in love with a property that he or she cannot get.
Right.
I mean, you run the risk of losing that client. They may not want to go look at other properties.
Right.
So it's something that creates harm in the community. It's misleading to the poor buyer that you brought in the door.
Right. Yep.
So, you know, that would fall under Article 3. You cooperate, you let them know when there are executed contracts. If there's any change in compensation, let's say you're the listing agent, and there's going to be a bonus or something like that, or they want to reduce it, it has to be communicated to the other realtor before they make an offer.
Okay.
You can't, once an offer's made, you can't go back and say, oh, by the way, the cooperating side is instead of 3%, it's going to be 2%. And I've had those hearings as well. So that's Article 3.
Before you get into Article 4 here, let's just take a little short break, and we're going to be right back in 1 minute. Thank you.
Thinking of buying or selling a home in Naples, Marco, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group associated with the #1 brokerage in Naples, Downing Fry Realty, which produced $1.9 billion in sales in 2014, controlling 43% of all transactions in Naples. Jim, Michael, and Morgan York make up the York Real Estate Group of Downing Fry Realty. With over $250 million in sales transactions, they can offer you the expertise and trust you want and need in a realtor. Call them today at 239-273-6727 or visit their website, www.naplesyorkrealestate.com.
Welcome back. Don, let's go to Article 4 here and see how that affects our ethics.
Well, Article 4, I can speak from personal experience. You're supposed to disclose whether you, as a realtor, have an interest in whatever it is you're trying to sell. Direct, indirect, whether it's your cousin who's selling the property, anything like that. You need to disclose it. If it's a corporation or LLC, you need to disclose it because you're being deceptive by hiding things like that. Your motivations are different. They're not to where they should be. As a practical matter, and I get this a lot, realtors will list their own property. My beloved dad listed his property and I was one of the owners. And selling that thing was very, very hard. Because buyers just don't trust that you're going to be objective about your own property. And how can you be totally objective? Even your subconscious is going to play into it to some extent. So that's why we have in all the contracts, or we recommend you put in all the contracts, that if you were selling your son Michael's property, for example, you'd put in there that, you know, Michael York is, my son, you know, right in the contract, so that there's no misconception or a lack of understanding on the buyer's behalf. It even goes so far as if, and I've had this, where you know, realtors have relationships, say, with inspection companies. I know a lady agent whose husband owned the inspection company, and she would routinely recommend her husband. One unhappy buyer reported that as an ethics complaint, and she was sanctioned. There's some theory out there that you're supposed to refer, you know, when your buyer asks for inspection companies, that you have to give 3. There really isn't. Again, using my dad, who was very successful, he's 82 now, he's retired, but he would refer people to me, but he'd always say, you know, my son Don is a genius, and you know, he'd just lay it on. He's very clear and biased. It's so obvious. He thinks I walk on water. So, you know, in that situation, he disclosed to the nth degree. Disclose your relationships. Be open. Make believe you're dealing with your mother. I mean, it's really the golden rule.
Okay. How about the next article there? 5.
Is it 5? You shall not undertake to provide professional services where you have a present or contemplated interest. Again, it's related really to 4. You're not just a realtor, you're not just going to get a commission. You or somebody you know is going to get some of the proceeds. It goes back to honesty, our first one, which is really, again, the crux. Disclose, disclose. And you know, agents get into these situations, and from my personal experience, you build your reputation over time. I mean,
Right.
I know which realtors I can trust. I know which realtors will do what they say they're going to do when they tell me that. I don't need to have it confirmed in writing, although I like to have something in the file in case I keel over. But
Right.
you know,
Yeah.
your reputation, you know, if you try to get too clever on any one deal, it's going to turn around and hurt you in the long run. It's going to affect the rest of your career, and it's going to affect your ability to represent other buyers and sellers down the road, because nobody will trust you.
Exactly. That's how you build a business, is
Yeah.
trust. So, okay, how about Article 6?
That's a good one. The agents, the realtors, are not entitled to get commissions or rebates unless they get the knowledge and consent of their customer, I guess is the phrase these days. Goes back to, I think, in Pelican Bay, and I forget whether it was 10, 20, probably 20 odd years ago, the builders in the preferred builder program were paying commissions to realtors. The realtors would sell the lot, and they'd get a commission on that, and the
Right.
client would see the commission on the closing statement, and then they would, you know, the customer would have to use one of the preferred builders at Pelican Bay at the time, and they were paying commissions to realtors, and it wasn't being disclosed.
Right.
Well, you know, that is a clear violation. You've got to disclose if you recommend a particular builder. Hey, this builder, if you use him, he's great.
Right.
But just to be open and honest here,
I'm going to get a commission.
yeah, and you get, and I think NABOR has a form on this,
Right,
where you know, for builders,
Right.
where they'll acknowledge being told this, and they consent to it. They have to give you permission to do it. So anything like that where there's a kickback, and a kickback is a pejorative word, but a commission by a builder, you know, is probably the best example. You need their permission and consent, you know, in writing.
In number 7 here?
What is number 7? Oh, okay. You may not accept compensation from more than one party, even if permitted by law, without, again, disclosure and informed consent. Whatever informed consent is, I really don't know. I mean, that's a tough one. You gotta really qualify your customer, and if it's somebody who's elderly and just doesn't understand the technical legal language here, you got to be very careful. There are, you put it right out in writing that if you have a buyer broker's agreement, then you've got the listing agreement, or
Right.
just put it right on the closing statement, get them all to sign, and hopefully have some sort of amendment to your listing agreement permitting this as well.
Don, we're going to take a little short break, and we're going to go to a little commercial from New York Real Estate Group, and we'll be back in 1 minute here.
Okay.
Thinking of buying or selling a home in Naples, Marco, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group associated with the #1 brokerage in Naples, Downing Fry Realty, which produced $1.9 billion in sales in 2014, controlling 43% of all transactions in Naples. Jim, Michael, and Morgan York make up the York Real Estate Group of Downing Fry Realty. With over $250 million in sales transactions, they can offer you the expertise and trust you want and need in a realtor. Call them today at 239-273-6727 or visit their website, www.naplesyorkrealestate.com.
Welcome back. Don, let's skip over a few here and go to Article 10, okay? Because just explain what that's about.
Article 10 starts our duties to the public, or your duties to the public, and the biggie is you can't discriminate at all. Race, color, religion, sex, handicap, familial status, national origin, gender identity. I mean, you cannot discriminate. And I can tell you what happens in a situation like that. They end up filing a complaint with HUD. And we had this about a year or so ago, and I personally was involved in it. We had a tenant who was refusing to allow the showing of the property. The owner wanted to show the property. It was listed for sale. And it was right in the lease that the tenant would allow the showing of the property with 24 hours notice. And the agent would call me and this lady won't let me in, and could you write a letter? And I'd write a letter saying that your lease says and you need to let this person in. And it ended up being that the person had some sort of handicap, might have been deaf. I think she was deaf. And she filed a complaint with HUD in Washington, D.C.
Oh.
And I can assure you, Mike Hughes at Downing Fry was not happy. It was a very uncomfortable situation to go through. And of course, my response was, A, I had no idea the person was deaf, and B, why would I care? I mean,
Right.
I don't. Everybody has something, but I can't imagine why you would discriminate against a deaf person.
Right.
And it's just complying with your lease.
Mm-hmm.
So, the Article 10 deals with discrimination and how you can be penalized for it. And again, $15,000 penalty. You could be suspended up to a year. Worse, they could go to the Florida Real Estate Commission and have your license revoked. So that's the scary thing.
Wow.
You do not want them to go there.
In Article 12, which talks about painting a true picture in your advertising.
Well, you just came back from the 3-hour class. I hope you stayed awake during that thing. But
We had a good teacher.
oh, good. I always have trouble with those. But you have to be honest and truthful in painting a true picture of the property. Not only for ethical reasons, but you can be sued later on if it doesn't measure up.
Yeah, a couple examples they gave, I think I touched on it earlier in the show, was, the largest lot in the community or the best location. You can also get in trouble for showing a house that in your photographs that's furnished, and then when they get there, it's not furnished. So, because you're misleading them when that the house looks a lot nicer when it's furnished versus when it's there's no furniture in there.
Well, I've got to say, I mean, you read all these things, and it was yesterday you asked me, to discuss these issues. 25 years, I've gotten all the ethics complaints and all the arbitration complaints, and I haven't gotten that one.
Mm-hmm.
But I have had ones where dimensions of a lot were rectangular in MLS, and it was a cul-de-sac lot, and that ended up being a massive lawsuit, which cost money, even though any person could walk the lot and see. Obviously, it's not a rectangle.
Yeah, well, they said that you should put in the MLS, somewhere that it's not furnished at this point or something like that. Just disclose. So. The other thing they were saying was that we have a hard time getting appointments sometimes with realtors. They don't return the calls. We're trying to schedule appointments. You call 2 or 3 times, and it happens often. Okay, so they suggested that you could file an ethics complaint, but if you've called 2 or 3 times, you should call the broker and just say, I'm going in the property. I've called 2 or 3 times and have no response, and that is legal, I guess, to go through the property. That's something I did not know. That's something I did pick up in the 3 hours.
Well, here's the problem, and I get customers who want to file an ethics complaint against somebody. I get realtors who want to file an ethics complaint against somebody, and they're usually angry. They're upset. They didn't like the way the thing was handled. They're from another state where things are handled differently. And my personal philosophy and what I tell them is, make sure you're doing it for the right reason. If you're trying to educate the person, maybe an ethics complaint would result in them taking additional classes. So it might be good. If you have somebody who's really just a dishonest, lying, cheating, borderline thief, you want to protect the public, but you better darn sure make sure you're going to win. Otherwise, that person will be your enemy for life, and when you make a simple human error, which we all do, they'll be the first ones to jump all over Jim York. So
exactly.
You don't want your time to be wasted. You want to have it result in something positive. something
Yeah.
good, not just be vengeance.
I think you got, my personal opinion on filing a complaint would be it'd have to be over the top to do it. It's just,
Right.
nobody wins. If you wanted to send a letter to the broker, maybe explaining what happened, and maybe they could talk to their agent, might be a better way of doing it, or a more professional way of doing it.
Well, I tell agents, and again, this exact situation, you call the other agent, and rather than it be confrontational and say, hello, Jim,
Right.
I showed the house, there's no furniture in the house, and I've done this in the past myself, and then it was pointed out to me that that's not the
right.
appropriate way to do it. So it's not so much of a
confrontation.
I know everything and you know nothing and you're
Right.
stupid.
Yeah.
It's like, been there, done that, I can feel your pain, and resolve it. And during that process, you're able to evaluate whether the person is basically a good person who's just learning his trade.
That's right.
At that point, and
Right.
you're educating him, and you're doing it in a nice way. You're practicing the golden rule, which is again what we're supposed to do.
How about Article 13 is a very interesting one. Something that you might know about.
An unlucky number. Oh, the unauthorized practice of law. I love this one.
I know. I figured this.
I don't know how you practice doing what you do without practicing law. I really don't. My favorite.
It's written. The contracts are written by attorneys.
Anything where you're doing more than fill in the blank, you're practicing law.
Right.
Anything other than putting in the buyer and seller's name, the price, the location, the closing date, is practicing law. And the approved lease forms, for example, by the Florida Supreme Court, have big disclaimer language in there that the agent is not allowed to explain the terms of the lease or any of the provisions of Chapter 83. Yet, every single day, how do you get somebody to fill out a contract without pointing out, oh, here's your closing costs, and here's the inspection period, and oh, here's the financing contingency, or maybe we want a due diligence period. If theoretically, explaining that contract is practicing law. But what I tell the agents that I speak to is that if you're going to write anything in under other terms and conditions, or the the totally blank addendum where you're writing in additional terms to the contract, email them to me.
Right.
So a lawyer has seen them.
Seen them.
And usually there's some fatal flaw in there. I mean, I had one yesterday. The buyer is all indignant because they can't close early. The contract says the closing shall be on or before such and such a date.
Right.
I said, well, you need the consent of both sides. What you really needed to do was that the closing date shall be this date, but the buyer with 5 days written notice to the seller may elect to close
Earlier.
Right. So it's a specific condition, and it only needs the consent of the buyer.
Right.
So little things like that, or closing date shall be 15 days after the sale of our Connecticut home. Well, what if the thing never sells? It goes on forever. So that's practicing law when they write things like that in there. And it usually takes me a second to look at it and point out that you might want to have a drop-dead date by which the Connecticut home is going to sell. Otherwise, the parties won't know, whether the contract's still in full force and effect or not.
Yeah, and just before we end the show here, is on a contract, you're not allowed to cross out anything. It should always be in an addendum to the fine print of the contract.
It's better to do it
Right.
that way. I see some people who do it. I know some people teach it that way. It's not a violation of any copyright law to do that. The reason agents, I think, are told not to do that is that all the provisions of the contract, we have like the 10-page NABOR
That's
contract,
right.
they interrelate with other paragraphs. So you might think you're doing something simple, but you're really affecting, if you're making a modification in standard G, it might affect paragraphs 3, 4, and 5, and you don't even know it. So you're better off with the addendum. And also under the contract rules of construction, handwritten changes control, so the addendum is better. And again, when you get into a situation like that, call a lawyer. I mean, it takes 2 minutes to make sure that's correct. I get a lot of people who, they will waive their rights under the inspection clause. And the inspection clause includes the obligation to maintain the property from the date the contract's signed, the effective date, to the closing date. So you always got to throw back in, that except for your obligation to maintain the property and keep it, and deliver it in room clean condition. And that's practicing law. If you don't do it, plus you may end up being sued.
That's right. Right. Well, Don, I think we've covered a lot today. I think maybe we've covered half of the items on Articles through 17, but maybe one of our future shows, maybe we could continue this conversation.
Sure. Be happy to, Jim. Thanks for having me.
Thank you. Thank you.